Hey guys, Lisa Figueroa here, board certified criminal defense attorney in Orlando. Back to talk to you about Alicia Andrews. We have an update and I wanted to let you guys know. Last time I talked to you guys about Alicia Andrews, I mentioned that Andrews' attorney has 15 days, if they want, to file a reply to the state's response to their petition. And just in the nick of time, now their deadline was yesterday or the 20th. They have to file something by the 20th if they want. And technically when something is due on that date, it's deemed accepted as long as it's filed before midnight. But Alicia Andrews' attorney filed it in plenty of time. They filed it just around noon. Oh, no. Wait, I'm looking at what is 11 p.m. They actually filed the response at 11:59 and 24 seconds. So they met the deadline of filing it before midnight, and it's deemed timely as long as it got filed on the 20th, which was yesterday. And so what did they say? Now, their response was a 10-page response. And obviously, this isn't the only case that Alicia Andrews' attorney has, but they did file a response. And if you recall, when we talked about the state's reply, the state's response, they indicated that Alicia Andrews only brought up 4 points. And remember, we went through the 4 points. So Alicia Andrews' attorney files their reply, and he comes out the gate saying that rather than respond to the claims put forth by Ms. Andrews, the state seeks to minimize and downplay the clear-cut examples of bias which reasonably caused Ms. Andrews to fear that she could not get a fair trial or hearing. The trial court's immense effect on Ms. Andrews' right to a fair trial is well documented in Ms. Andrews' petition for writ of prohibition. Ms. Andrews raises 4 issues collectively supported by no less than 14 different examples of judicial bias, not 4 as the state represents. So they're calling the state out on what they said, saying we didn't just bring up 4, it's summarized, it's collectively, it's like 4 groups of things, but we provided no less than 14 examples, different examples of the court's bias. They also bring up the fact it says the state failed to respond to 3 of the 4 issues raised by Ms. Andrews. Instead, the state created its own arguments for Ms. Andrews and responded to those arguments. Such a response is commonly referred to as a straw man fallacy, an attempt to distort and misrepresent the actual argument. So this whole straw man fallacy is basically the straw man argument. It's like, I'm going to recharacterize your argument in this way to make it easier to knock down, but they're really not addressing the issue. It's like they're arguing against something that's not there and kind of just trying to throw the appeals court off of what the real focus should be. At the top, kind of in summary of their preview of their full argument, they point out that even though they feel Ms. Andrews' writ of prohibition was sufficient for the court to grant relief, the state's failure to respond is fatal, and so the writ should be granted. What does that mean? They're saying that we brought up some issues that the state didn't even counter. They didn't talk about it. So the fact that they didn't, it's fatal, meaning that they lose. If Alicia Andrews came out with 4 points and they only addressed 3, then that one that they didn't even talk about, it should go to the person that brought forth the motion as long as they presented enough. And they're saying that there were multiple arguments that Alicia Andrews' attorneys raised and they didn't even bother to talk about that. And that's why they said the whole straw man thing. It's like, hey, they're saying this is all we talked about, but that wasn't. And now they're going to go through each of their arguments. Argument 1, preservation of the issues. And again, this is the argument that Alicia Andrews' attorney is making to counter the reply or the response of the state. So they're saying the first thing the state talked about is preservation of the issues. The state's preliminary argument is that Ms. Andrews did not preserve certain issues for this court to entertain. Ms. Andrews' intentional abandonment of certain issues originally raised in her motion to disqualify the trial court is of no consequence here. The preserved issues raised in her petition are more than sufficient to warrant disqualification of the trial court. The state is saying that she didn't preserve her right to make certain objections if they didn't specifically say it in the writ. And Andrews' attorney is saying that she didn't abandon those issues. She raised those issues in her petition, and that when she filed the motion to disqualify the court, so all of this is the appeals court trying to decide what should be done. But Alicia Andrews' attorney filed an actual motion to disqualify disqualify the judge. So everything that they put in that original motion, it's like that comes under this same umbrella. They don't have to reassert all of that. That's actually what's being reviewed. So they're saying it was preserved because it was already put in the original motion to disqualify. And beyond that, everything that was brought into this petition, the appeal, it's enough to warrant, to deserve disqualifying the judge. Then the second argument they go to is properly framing the issues. In its response, the state incorrectly summarizes the arguments raised by Ms. Andrews in her petition. The state also limits its response to these 4 incorrect bases, failing to respond to the actual issues raised by Ms. Andrews. According to the state, Ms. Andrews' petition is limited to, and we had kind of talked about these, 1, the trial court sustaining an evidentiary objection; 2, the trial court's handling of the defense request to introduce photographs via flash drive; 3, the trial court assuring the jury that they would have the case by Friday, October 31st, 2025; and 4, the trial court asking the defense to fast forward through video evidence of Ms. Andrews' interrogation. So they're saying that that summary of the 4 issues is an incorrect restatement of what they were saying. And here he goes on page 3, he's saying, in reality, Ms. Andrews raises 4 main grounds for disqualification of the trial court. 1, the court's hostility towards defense counsels; 2, the trial court's repeated attempts to enter the fray, like to get involved in the mix between the attorneys or the witnesses; 3, the trial court's hostile treatment of defense witnesses in front of the jury; and 4, the trial court's efforts to rush the defense case in chief. The defense case in chief is like when it's their turn to put on the case and put on witnesses. Each ground raised by Ms. Andrews is supported by specific examples of clear-cut bias which caused Ms. Andrews to reasonably and objectively fear that she could not receive a fair trial or hearing. Now they're going to lay out. They're saying we gave clear-cut examples of the bias. And now it says, A, the trial court's hostility towards defense counsels. Now they're going to go through their 4 main grounds. A, the trial court's hostility towards defense counsels. Ms. Andrews cited at least 6 examples of the trial court's hostility towards defense counsel. And it's plural because there were multiple occasions that the court maybe got a little snippy with the various defense attorneys for different issues. 1, the trial court refusing defense counsel's request for a sidebar. I remember that one.
Judge, I would object to the question is phrased, what are they connected to, is vague.
I'm going to sustain the objection, rephrase.
What is the purpose of these, of showing these rifles to the jury?
Objection.
Sustain the objection. No. Sustain the objection.
What is the purpose of showing why there's a safety on this firearm, on these
I'm going
rifles?
to sustain the objection.
I don't even know what the objection is at this point. There's no legal basis. It's just an objection.
It's
Objection to
irrelevant.
the speaking.
It's
objections
irrelevant
by
and it's
counsel.
improper question.
It was elicited in front of the jury.
Mr. McClement, I'm not going to argue with you. If I allow the witness to testify, then that makes it relevant and material. Okay?
And if it's relevant, then I should be able to
Objection,
cross-examine
Your
on
Honor.
it.
I'm going to sustain
Can we
the...
come sidebar?
The jury.
No. No.
So I can't argue. I can't come
Objection.
sidebar.
Mr.
This is
McClement,
improper for him to do
please
this in front of the
stop.
jury, Your Honor.
It's improper.
It's disrespectful, too.
I asked to come sidebar.
And the answer is no, we don't need to sidebar it. If the witness was permitted to testify something, that makes it relevant and admissible.
I'm not arguing that, Judge. I just want to talk to her about what she testified to.
Listen, I've sustained the objection. Ask your next question.
And allowing the state to say that defense counsel was making improper and disrespectful comments all in front of the jury. And then they cite where in the record, where in the appendix, the appeal judges can find that. 2, the trial court admonishing the defense, that's like regañando, scolding the defense and not the state for alleged violations of the rule of sequestration while suggesting the defense was unprofessional. So the rule of sequestration is that when witnesses testify, if the rule is invoked, you'll hear attorneys say, well, I'm going to invoke the rule. That means that the witnesses are not to talk to each other or anyone else about their testimony, and they're not supposed to be aware or watch any other witness's testimony. 3, the trial court falsely accusing defense attorney Jeremy McClement of accusing a state witness of watching the trial online. Yeah, I remember there was some discussion about that, and obviously the defense took issue because it was like, you're saying I did something that I didn't do. And again, they cite where in the appendix that's referenced. And then 4, the trial court's visible display of hostility towards the attorney during cross-examination, again citing it. And 5, the trial court sustaining objections without any articulable basis, citing again the location. And then 6, the trial court denigrating defense attorney Yeseli Herrera.
Ms. Herrera, stop. Ms. Herrera, stop. I didn't ask you to talk.
I didn't know I had to ask.
Yeah,
I
you
just wanted
do.
to make a point.
You do. Stop, Ms. Herrera, you need to stop right now, because you know what? You've been making faces throughout this entire trial. This entire trial, yeah, you have been.
Okay.
And everything's been caught on video.
I know, and I also hope that the court has caught and noticed all of the gestures and the tone which was addressed yesterday from the state. But it's fine, no problem. I will do my best to.
Please, do your best. Yeah, and your attitude is very disrespectful. I'll note for the record. Okay, very good. If you wouldn't mind moving, let's bring him back in.
Thank you, Your Honor. Yes.
All rise.
So denigrating, putting down, speaking condescending, or just criticizing or belittling her. And I'm sure you guys probably saw that snippet. Again, they lay out at least 6 examples, not saying that that these are the only 6 examples, but they are saying we cited at least 6 examples, and they went through 6 right there. All right, page 4. Each of these instances, as detailed in the original petition, speak to the trial court's bias shown through its hostility aimed solely at the defense counsels in the case. Ms. Andrews witnessed these incidents, which individually and collectively, so each one was an issue, right? But collectively, all together, cumulatively, the impact of all of that caused Ms. Andrews to reasonably fear that she could not receive a fair trial or hearing. And then they cite a case law, because when these things happen, they have to put forth that the defendant, whoever the accused is, because of these things that are going on, they feel that the trial judge is not going to be fair in their case when it comes to sentencing or making any future decisions related to their case. Then they cite a case, Gates versus State, and they say that in that case, they put in parentheses, kind of like, what does that case stand for? And that case they cited says that a trial court's prejudice against an attorney may be grounds for disqualification when such prejudice is of such a degree that it adversely affects the litigant. Adversely, meaning negatively, affects the litigant. And then they cite another case saying that this other court, second DCA, mandated recusal where the judge repeatedly expressed personal disapproval of counsel, questioning his professionalism, suggesting he routinely violated good faith obligations, publicly issuing orders out of distrust, and labeling his statements about understanding Spanish as incredulous. So again, when attorneys cite case law, they go and try to show another situation where an appeals court has found that this behavior or this conduct is a problem or against, and he's citing another case that says, look, in this occasion, the appeals court said this was a situation when the judge did these things. It was mandated, meaning mandatory, that they should recuse themselves and come off the case. And with that one, what I just listed out, there's some similarities with what they're alleging happened in the Andrews case and with what happened in that case. And then another case, Brown versus St. George Island, a statement by the judge that he feels a party has lied in a case generally indicates bias against the party. So they're saying in that case where the judge said something that made it seem that someone, one of the attorneys, a party, or someone involved in the case was lying, that showed bias. And they're citing that case to say, likewise, in the Andrews trial, when the judge made this comment about him not being truthful, or where they say that the trial court falsely accused defense attorney McClamant of accusing a state witness of watching the trial online and all of that stuff. So they're saying, just like in this case, the judge should be removed. And then they go on and cite some more cases. Another case where the person, one of the parties, believed that she couldn't receive a fair trial because of the trial judge's comments and behavior towards the attorney. So here they're focusing on cases that it's not that the judge has said anything specific about the accused. So you notice there's not a lot here where the judge is commenting something specifically about Alicia Andrews. I had a case where I asked to have the judge recused, but they made a comment about my client, like, oh, because he thought he could get away with it or something like that. And that was obviously directed to the client, to the defendant. Here they're citing a bunch of case law where the judge has been removed or said that should be disqualified when they make statements about the lawyer, that it's just as prejudicial or harmful if the trial judge is saying these things that are condescending, that are showing bias towards the defense attorney or any of the attorneys, really. Some of the cases that they cited are actually a civil case, not even criminal, but it just goes to show what the law is related to removing and recusing a judge and when a judge should be disqualified if the person can't receive a fair trial due to the judge's comments and behavior towards the attorney. And then the last one that they cite on this page, Franco versus State, finding the motion to disqualify judge for fear that he will not be sentenced fairly should have been granted, where the defendant asserted, inter alia, that's one of my favorite words, inter alia, and that just means, among other things, that the judge's facial gestures and conduct exhibited a lack of control and lack of judicial temperament. That's interesting. So I didn't know that that's such a case, because judges do that. They'll make comments or just, so even gestures, facial gestures, and conduct exhibiting a lack of control and lack of judicial temperament. And then they have this area of indented text. So this is a quote out of one of the cases that they presented. Though a client and his counsel are separate entities, they share a common bond forged by the attorney-client relationship and tempered in the rigors of litigation. Most clients find the courtroom to be an unfamiliar and in some instances uncomfortable atmosphere. And so it's not unusual that they entrust themselves into their counsel's care and view their interest as one. Thus, it's understandable a client would become concerned and fearful upon learning that the trial judge has an antipathy toward his lawyer and has expressed the opinion that the client's counsel should not be in this case. Antipathy. So against them, like they got something against that lawyer. And so they're saying, look, I hired this lawyer or I have this attorney representing me, and clearly the judge has an issue with my lawyer. And if I feel that they don't like my lawyer, it's going to naturally make me feel like the judge can't be fair to me, because it's like they're going to hold it against me what my lawyer is doing. That was their point on that one. And then B, it goes on to say the trial court's repeated attempts to enter the fray. They kept getting in the mix. So the judge is getting in the mix. The judge is supposed to be a neutral observer and arbiter, referee of the proceedings, but they shouldn't interject themselves more than necessary to keep the flow of the trial going. So let's see what they point out here as to supposedly be entering the fray. Ms. Andrews cited two examples of the trial court's repeated attempts to coach the state in front of the jury while continuing to disparage the defense in the process. One, the trial court's tenacious suggestions that the defense improperly put items on a flash drive that was being introduced into evidence in front of the jury. Did you guys see that? I don't remember seeing that. But I guess they're saying there was a part where the defense is trying to introduce a flash drive into evidence, and there was a suggestion by the court that they are putting items on a flash drive that weren't supposed to be introduced into evidence. And if that's true, I totally see their point. And two, the trial court sua sponte. Sua sponte means without nobody asking, they just interject on their own volition, on their own accord. The court sua sponte interruption of Mr. McClymont during the defense closing argument to tell the jury and the state that an objection should have been made earlier in the trial. That one I remember, because that one kind of blew my mind. These examples of the trial court's bias can also fall under the first issue, the trial court's hostility towards defense counsels. However, here they are sufficient to disqualify the trial court for becoming a participant in the trial. So when the judge is interjecting themselves, they're saying not only is this another example of how the trial court was showing bias, but it's also an example of the judge improperly interjecting herself in the trial without being asked, sua sponte, into the fray, just jumping in. They go on to cite a few things about just different case law about judicial neutrality, the judge being neutral, and examples of where the court interjecting itself, like jumping into things that they shouldn't be jumping into, where that ended up being a problem. And then, yes, so the next section is C, the trial court's hostile and disparate treatment, disparate treatment of defense witnesses, so that they treated defense witnesses differently than they treated the state witnesses. And then they go through some examples. Ms. Andrews cited 3 examples, and they say Ms. Andrews, but obviously Ms. Andrews through her attorneys, 3 examples of hostile treatment towards defense witnesses. One, that the judge refused to let defense witnesses have the same protections the state witnesses wanted, to conceal their identity from the public. I think there was like a Uber driver or something that was a state witness, and they were able to conceal his identity, but the defense witness was not given that same opportunity. And then 2, the trial court commenting on a defense witness's credibility in front of the jury, and they cite where they showed that. And 3, the trial court chastising a defense witness in front of the jury who didn't understand a court ruling. And then they go through and explain that basically seems like one of the defense witnesses didn't want to say who else. There was a question asked, and then they wanted to know the names of whoever she was talking about, and she's thinking these people don't have anything to do with it. I don't even know if it was a she. But anyways, I don't know. For some reason, I got the impression that it was a female. But either way, that the witness didn't want to give the names of these unrelated witnesses. And the court said, you're refusing to give their names. You're under oath to tell the truth. So again, kind of an admonishment, which I think maybe is fair. But when the witness again said that, hey, these people are unrelated to the case, the court retorted, kind of snapped back, well, I guess you're the judge now. I don't know. We'll have to find that clip. I'm not sure how the tone was, but well, I guess you're the judge now. The witness explained that the witnesses were not involved in this. And the trial court, according to the attorney for Alicia Andrews, said the trial court in a sarcastic and demeaning tone said, these comments effectively told the jury that the witness was being evasive or dishonest. So by making those kind of comments, the judge might give the jury an impression. Now, at the end, I don't know if you recall, but in any criminal case in Florida, there's a line in the jury instructions where it says, the judge reads this and says, if please, I don't know if it's forgive, but basically, please disregard anything that I did that made you think I favor one verdict over another. So basically, no matter what you may have heard, disregard anything I said or did that might make you think that I favor one verdict over another. So that is there to kind of even the scales if for some reason they kind of got a vibe that the judge felt one way or another. At the end of every case, they do tell the jury, hey, regardless, don't think that. But these are things that the defense feels, even with that instruction, the jury was tainted or affected by it. And then they talked about the court calling the witnesses' credibility into question, and then they cite some case law and the actual rules of Florida statute that says that the judge can't sum up the evidence or comment to the jury about the weight of the evidence or the credibility of a witness, which is what they're saying that the court did in this case. And then D, the trial court's efforts to rush the defense case in chief. So multiple times the judge says, hey, we're going to get this case to you by Friday. We're going to get this case to you by Friday. And then when it's the defense's turn, they're kind of rushing them through it. And they said that was another reason that it showed bias, that they didn't have time to kind of slowly present their case or however they want to present their case because they're on this timetable because it was promised to go to the jury that Friday. And then they cite some case law, and they actually, on page 8, they actually cite a case that the state brought up, and they're saying, hey, the state brought up this case, and it actually shows what we're trying to say, the point that we're trying to make, that yeah, the judge can manage the courtroom, but it needs to be conducted fairly, efficiently, and expeditiously, ensuring that both sides have a fair share of the court's time. And they're saying we didn't get equal time. And then the last thing was kind of what I touched on at the beginning. They had put it in at the beginning. The state failed to address the first 3 bases of Ms. Andrews' petition. So in their last, this is page 9, the state failed to address the first 3 bases of the original petition. And the fact that they didn't address it, then that means it's like a default. They automatically win. And we know that they only have to establish a prima facie case. That means a very limited level of proof that these things happen or that this is enough. And I think the fact that the court said, hey, state, you need to respond, shows that they did, at the very least, present a prima facie case for relief. And so Alicia Andrews' attorneys is saying, look, there's 3 points that we brought up that the state didn't even address. So just with that, we should win this. Anyways, that's it. I mean, that's their response. They got it in the nick of time. Now we don't know. Will the appeals court respond in a week, a couple days, a couple months? It's usually fairly quickly, but quickly could be a couple of weeks. We'll definitely be keeping tabs on it and then get back with you guys as soon as they have a ruling. And one way or another, though, everything's in their hands now. State responded, defense had their final rebuttal rebuttal, essentially, and now it's in the higher court's hands. So that's it. Now you've heard everything that they're going to say, and it's up to the court to decide. As soon as we hear back from the appeals court, we'll be back with another video and let you know what the verdict is from the appeals court. Take care.